Hello. In this session, we will discuss vexatious and belligerent litigants. What is that? Let's get started. A vexatious litigant is where the court has inherent power to what is called manage their proceedings, and then they turn around and label you what is called vexatious or belligerent because you challenge the court's jurisdiction or challenge the judge or challenge anything regards to your child support case. And that's Chambers versus Nasco or State versus Curie Perez of the First Circuit. Now, to you as a father, what does that mean? You're now in fear because if you're labeled vexatious litigant, which is a person that's litigating before the judge who time after time talk about you want to exercise your rights. And in some cases, these judges or magistrate then hold you in contempt or indirect contempt. Now, I have here California Civil Procedures 371 and 391. Every state has this statute. So here you are fearful of saying anything before the judge. You don't want to say anything. You're liable to risk going to court or this is go to jail or all of that fear in your head, and therefore you somehow does not get an opportunity to exercise your rights. Well, what does that mean? How do you exercise your rights? Well, Ben Franklin, Thomas Jefferson says, if you give up essential liberties in order to obtain temporary safety, then you don't deserve liberty at all. So how do you balance that? Your need to have your rights in court, likewise the courts having push their rules upon you and in essence punish you for it. In this session also we'll talk about a little quiz. Can you sue a judge if you're labeled vexatious litigant? Let's get started. Hello, my name is Chris, and in this session we're going to talk about sort of a problem in court where the judges, magistrate, inflict their rights, their rules on you and are anticipated that you will just follow without any question. We have a video called How to Sue Judges. Please feel free to watch that video. The stuff that's discussed here will not be included in that video. Also, please tune in to us on our podcast. We're on Spotify, Amazon, Apple as well. And from time to time, we ask for your support. We bring you this research and we ask for a small donation. $5 on a Cash.APP is welcomed. We ask for $25 either on PayPal or Cash.APP, but any amount will be very much appreciated. So let's talk about this category called belligerent in person. It reads, the belligerent person is someone who is not passive about their rights, and they're not ignorant of their rights, and who are willing to come to court and argue with judges and magistrate. It is also a fighting clause. That is, if you want to maintain your rights or support your rights, it's combative in court. Next, an attorney cannot do this for you. If you hire an attorney, they cannot go to court and be combative. And we'll talk about that in a few minutes. Next, if you are labeled belligerent or vexatious, here's the thing. It is perfectly okay. Under the Constitution, what is called the Confrontation Clause of the Sixth Amendment, you are anticipated to be a belligerent claimant in person. Yes, it's called belligerent claimant in person. And that's United States versus Gannon, and it mostly mentioned in U.S. versus Johnson and McAllister versus Henkel. So vexatious litigant. So who is a vexatious litigant? Well, attorneys and lawyers. You, as a pro per in court defending your rights, is a belligerent claimant, but a vexatious litigant only applies to attorneys. So you're in court and the judge labels you that you're disruptive and they're going to hold you sanctions. Well, here's the issue. Ignorance of the law is not a defense. If a judge takes this position, then he or she is ignorant of the law. Because, and again, that's not a defense for a judge not to know that it's okay for you to be belligerent in court. Why is that? Why can you be a combative person in court? Because the Sixth Amendment right, which says a party has the right to attend his or her own trial. It's an absolute guarantee. And even if there is misconduct in the courtroom, you never lose that right. And for many of you, this is what happens to you. The judge goes after your Sixth Amendment right, and you have to insist on it. The case law is Illinois versus Allen, which is you have the right to attend your own trial. If the judge gives you an attorney and you don't want one, again, this is your Sixth Amendment right. Next, if the judge continues to say that you're disruptive in court, that violates your First Amendment right to petition the court. Remember, you have that right. Saying the same thing as if you encounter a police officer or sheriff and you decide to argue with that police officer over your rights, well, it is fully protected. You probably heard the term that you can tell a police officer the F word and there's nothing he or she can do. Next is your Eighth Amendment right. That is, you have the right to be protected from what is called excessive bail. What is excessive bail? Well, you're in court arguing with the judge, and the judge says, I'm going to hold you in contempt for $10,000, $15,000. I'm going to command you to jail until you control yourself in court. Well, that is a violation of your Eighth Amendment right. Next, it also affects your 14th Amendment right, which is no state shall make or enforce any laws which shall abridge the privileges of immunities of the citizens of the United States. No state shall deny any person within its jurisdiction the equal protection of the law. Why is this? Well, many of these vexation status that on the books in all 50 states, it goes against your due process rights. Yes, by them putting it on the books in the legislature in the state that says these judges can label you vexatious, goes against your 14th Amendment rights for due process. Because why? You have a right to petition the court. So, what does that leave us? Well, if you're in front of a judge or magistrate or commissioner, the point is you cannot be a wimp or a simp. You cannot back down. I'm not saying being disrespectful, but you cannot back down, because if you do, you are surrendering your Sixth Amendment right. That is what's happening. So comment down below. For some of you who know what the definition of a simp is, please leave a comment. But this is combat when you go to court. So let's take a look at our quiz. We said, when you're labeled a vexatious litigant, can you sue the judge or a magistrate? That answer is yes. But before you do that, you need to collect your paperwork, the court orders. You need a court order that says the judge has labeled you vexatious or labeled you belligerent. You need that because that is your evidence within your lawsuit. You also need objections and affidavits. Basically, you need your paperwork. So once that happens, remember, you have to notify that judge or magistrate that you intend on suing them. And that's called a notice of a claim. Yes, you are required under the Constitution, the judges by the Supreme Court, that you must notify a public official if you intend on filing a lawsuit. And that is DeHart versus State of New York, or famous cases, Felder versus Casey. And that is a notice of intent to file a claim. And why is that? Well, if you're labeled vexatious, it is fraud on the court, because you have your rights. As I said, you have your Sixth and the Eighth Amendment right against any judge. And if this judge decides to do this to you, well, they're not acting in a judicial fashion. They're acting in a administrative fashion. And whether they're from the state or federal, it doesn't matter, because your rights being violated is not a judicial function. It's administrative. Also, you may want to consider what is called a color of law document as well. I've already done a video on that. Please look into that if you don't know what that is. So when you file a lawsuit against a judge, they will hit you with what is called a defense of a 12b6. And we can talk more of how you overcome this. But before we do that, I'm going to break in this video. I am asking, in order to continue this discussion, I want everyone to ask your friends and share this video. I would like my subscribership to be increased. Yes, I am asking something very simple. Increase the subscribership such that more people will get this message when I release it. And I'm happy to discuss the rest of this topic. All I'm asking for is increase in my subscribership. So what are we going to be discussing if we were to discuss this topic? Well, there's 4 rules to being a vexatious, belligerent, and what the defenses are against that. That's what we'll discuss. So please continue to support this channel. We ask for a small donation, and we will continue this because this is war. This is a fight. Being labeled vexatious litigant is an unconstitutional act by a judge, and therefore it is subject to a lawsuit. And here we are at the end. Again, thanks for tuning into this episode. Thanks. Have a great day.